Diana Kelly. I am the President and CEO of Camp Calnow RV Park and Campground Alliance. And I want to thank everyone for joining us for this webinar today. I hope you are enjoying them as much as I am. I always learn something from Dan Rudderow. So today we have Dan talking a little bit about 10 best rules you should have at your park. And these webinars have actually been developed based on questions that come into the association on a regular basis. So this is one that comes up fairly frequently. What rules am I supposed to have? How often do I update them? How do I present them? And today I'm super happy to have Dan Rudderow, our legal hotline expert, joining us to talk all about that. Dan is an attorney and his law firm represents the owners and managers of RV communities throughout California. His practice includes preparing rental agreements, park rules for communities, assisting with day-to-day management and operational issues at park communities, and also he would represent you in the event of a litigation case, mainly including those pertaining to evictions and rent control cases. So with that, I'm going to let Dan take it away.
Thanks, Diana. I really appreciate it. Hi, everybody. Welcome to our webinar today. Our presentation should probably take about 35 to 45 minutes. And while I'm talking, there's a little spot there that you can submit questions. And if you submit questions, we'll try to answer your questions at the end, time permitting. If I don't get to all your questions, usually we do, feel free to send me an email and I'd be happy to get back with you. At the end of our presentation, there will also be some poll questions. We've tried to ask you what you would like topics on for future webinars. So if you wouldn't mind giving us your feedback on the poll questions, we'll try to do some additional webinars on topics that you like. Okay, we have a lot of information to cover today, so let's get started. I started with this slide here about being, I was kind of being a lawyer with a little asterisk and saying that the term best shall mean. But what I wanted to say was there are going to be many rules that you have in your set of park rules, which are very important. You may have a rule like minors cannot use the pool without being accompanied by an adult. All those type of rules are very important. But today, given how many day-to-day operational problems that we see at some of our parks, given the number of questions we get in through the Camp Calnow hotline, and given the issues that my clients present to our firm, we see some reoccurring problems that happen over and over and over. So today's webinar is, let's talk about 10 different areas that, or 10 different problems that seem to reoccur in a park, and what would be the best rules for those 10 areas. Before we get started, I just wanted to briefly go over why is it so important that we have good rules and regulations. Obviously, the first reason is we have a bunch of people living in a community, and in order to not have total chaos, it's very useful to have one set of rules that the entire community, all of our residents, abide by. There's some other underlying reasons from a legal standpoint why good rules and regulations are really important. They really serve as the operations manual for management and for the manager. It's not just the residents following the rules, but on the other hand, it's the manual by which your park manager, enforces the rules and follows certain procedures. Why that is important is we want to avoid any liability, and specifically we want to avoid any liability for inadvertently committing any type of unlawful discrimination or harassment. So we don't want the park to get sued in a big discrimination, harassment, or failure to maintain lawsuit. And having good park rules where the park manager is following those rules as to every single person who lives in the park, it helps reduce or diminish our chances. If we're treating everyone according to the rules, it really does diminish the park's chances of being sued in a discrimination lawsuit. The flip side also, when the park decides that they're going to file an eviction action against a resident in court in front of the judge, the resident may assert certain affirmative defenses to the judge and say, Your Honor, I should not be evicted based on my legal defense. There are a few legal defenses that the tenant can raise in court. One of them is that the park unlawfully discriminated against the tenant or harassed or retaliated against the tenant. So if we have good park rules and we're equally enforcing the park rules and we're not playing favorites and we're not giving too many exceptions to the rules to anyone in the park, that also helps the park be successful in their evictions because it helps diminish the chances that we have a tenant in court claiming some type of affirmative defense of discrimination. Last two bullet points here on this first slide is it's very important. We'll talk a little bit more about that later. In both an RV park and in a mobile home park, and I'll be talking about both types of parks today, it's very important to document the rule violations. Rule violations need to be documented. They can be documented with, of course, the 7-day notice. And then those 7-day notices can be given to the attorney, but documentation may mean something more than a 7-day notice. It may mean taking photographs of someone who's hoarding trash in their carport. So whatever the particular violation is, we always really want to document because eventually, maybe not always, but eventually in some of the many cases or the many tenant files that we have in our park, we document everything, and maybe 10% of those cases that we're working on or problems that we're working on in our park, maybe 10% go to the attorney to do an eviction. And we just want to make sure that when that tenant file is transferred to the attorney, the attorney can see that all the violations were really well documented. Okay, so let's go to our first category. I say rule number one, but it's really the first topic that I want you to have rules on. I really want you to have rules that say in your rules what rental agreements and registration agreements they have to sign in order to be in your park. And it may seem kind of ridiculous. It may seem like, well, I don't understand. At the beginning, when they come into my park, I have them sign the rental agreement or the registration agreement. And why do I need a rule about that? We have a surprising number of cases where maybe it's just the rush of business or inadvertent mistakes, but we do have a fair number of cases at our law firm where, for whatever reason, the resident was able to come and start living on the space. The assistant park manager started accepting rent from the person, and we get 6 months down, 7 months down in the tenancy, and the park manager realizes that there is no required rental agreement with this resident. It then becomes kind of a sticky wicky because sometimes we've had situations where the resident is not very cooperative and they just won't come down to the park office and sign a rental agreement. And that's hard, and that's a difficult situation because the park manager by law, under California law, is required to have certain rental agreements in writing on the one hand, and on the other hand, the resident is not being cooperative and coming down to the park office and signing the rental agreement. So I have had on more than one occasion, several different clients have this same problem. They come to me and they say, I know I'm supposed to have a signed rental agreement. This one fell through the cracks, and the resident is refusing to come to the park office. What can we do? And it's hard because we say, well, you can, say to them they'll be terminated if they don't follow the rules. But then the park manager says, yes, but we don't have a park rule that says they have to sign the rental agreement. So I think it's really good in both the RV parks and in the mobile home parks that I think our office is starting to draft these park rules with some rules in them about what are the required documents that they need to sign. And on this last part, on number 6, documents like estoppel certificates, proof of insurance, maybe the exercise equipment or the pool release. These are things that are very key documents that you want them to sign and return to you. And so on this last part, on number 6, I just want to point out that I like to draft my park rules where we give them a deadline, you know, where we say that you must return the document or you must sign the rental agreement, you know, within 7 days, 10 days, 14 days of management's request. Why? Well, because you're trying to establish an opportunity for them to do what they're supposed to do, but you're not just leaving it out there. I mean, if you just leave it out there and don't give people a deadline, you're not going to get a response. And at some point, you're going to want to do that 7-day notice, and you're going to want to make a very clean-cut case in front of the judge that we have a rule that gave them a deadline, and they had this time to give me the estoppel certificate or sign the rental agreement, and they didn't do it within the 7 days, 10 days, or 14-day deadline. And in this one, one of these kind of cases, this is one of those kind of sort of minor rule violations where we talk about how many 7-day notices should I give. This would be a situation where, you know, you would probably talk about it with your attorney and decide that we'll give them 3 7-day notices to really remind them 3 times that they have to come into the park office and sign a rental agreement. But after 3 7-day notices, you need to make that decision if you're going to pull the trigger and go to a 60-day notice of termination of tenancy for the person in the mobile home park, or a 60-day notice for the person who's been in an RV park more than 9 months.
You know, Dan, I'm really glad you brought that up because that question does come up quite a bit. And it's very easy to get caught up in that game, right? Where they don't come in, okay, not a big deal. You know, it's super easy for all of us to say, it's all right, I know where you live, you know, not a big deal, until it is. And that's, with all these rules, I think it's one thing we have to remember. It's not a big deal until it is. And then when it is, it's too late. So
Exactly.
it's really, really important to stay consistent and stay on top of these things before it turns into, oh, don't worry about it, because that just sends you down a rabbit hole that you don't want to be in.
It's very difficult, and very difficult in a mobile home park especially, to compel people to come down and sign the documents. I mean, in a perfect world, you won't let them move into the space on day 1 until they've signed all the necessary documents. But like I said, excuse me, when they've already moved in and they've lived there for a while, it's surprising how many calls I've had where they won't cooperate and sign the necessary documents. So, okay, moving on. So the first one is, I really think we need rules that say what documents we need signed. And the second rule, or the second set of rules, and I love our IT person, Megan, she puts all these cute little cartoons to keep us awake during this presentation. I like this one. It looks like one of these park-owned, like park models maybe, huh, Diana? The little,
like
the little tiny home. Yeah.
Exactly, a tiny
Except
home.
they kind of cover up the wheels, but it's starting to remind me of like an RV park model. The second category I wanted to talk about was, let's be a little bit more explicit in our rules about who these people are that are living in our park and how they can be terminated. And in my mind, I kind of go 2 different ways when I draft these kind of rules. On the one hand, I know there are a lot of lawyers out there, including myself, who draft park rules and try to make them very verbatim, copying the statute. Whatever the law says, there's some lawyers out there that copy the law and paste it in the park rules. And I think you can get into a problem doing that, because every year, every other year, the law changes. And then if the law changes and your rules were perfectly tied to the law that way, then you're saying to yourself, well, are my rules, you know, out of date or in violation of the law? But I think that what we're seeing is we're seeing a lot of people in RV parks that are difficult to terminate. They don't understand how they can be terminated. And I err on the side of, maybe it's very useful in an RV park to have rules that simply say, you know, if you're in the park less than 30 days, you can be removed from the park upon a 72-hour notice. And maybe we should have rules that say, and if you're in our park, you know, up to 9 months, you can be terminated without cause. And then maybe we make it more vague and say, for a resident who's living in our park over 9 months, we'll say you can be terminated for cause. The rationale behind being so informative, on the one hand, you can say, well, I don't really want to educate, quote unquote, our opponent, the tenant, but I see day in and day out that sometimes the basic rules of who they are and how they may be terminated, they may see that in their park rules and know that that's just the way it is, and maybe they're a little bit more resigned to what you're trying to do and evicting them. So it's a case-by-case basis, but I do think there's some value in putting a little education out there so the residents can see that, and then maybe they're not, you know, fighting you so much later on. One thing, the last bullet point, we've had a couple of these situations. For some reason, I guess we've all known people like this, but I'm putting dad has son living there. We have a situation where in a mobile home park, the dad signed the rental agreement, and the dad has a 20-year-old son who, let's just say this 20-year-old son is kind of flaky and can't hold down a full-time job. And the dad has proceeded to move out of the mobile home, out of the park, and lives in a total different city. And he's basically let his son just live there by himself. And so it's have you heard of those kind of situations, Diana?
I'm laughing because yes, I have, as a matter of fact.
I don't know what we call it, is the dump the relatives thing, or you dump your relative, you know, in your home.
Yeah.
And
I had one of our parks, they went to go clear out the home. It's actually a trailer, you know, an RV. They went to go clear it out, and there was some guy in there, and they're like, what are you doing here? And he's like, I've lived here for 5 years.
Yeah, that's a problem too.
Yeah.
So in this kind of case, what we did was we said, okay, we get it. This is kind of unusual, although it's happened to 2 or 3 other my mother clients. Dad is not living there, even though he's on the rental agreement. And what's happening is his son is living there, and because that's where they want to stick the son. Well, you say to yourself, okay, let's do a 7-day notice on the dad and tell the dad, who's the person on the rental agreement, that you're violating our park rules. Well, you would think we would have a park rule, or maybe you would think we don't need a park rule, but you know, we don't have a park rule that says, quote, at least one homeowner needs to occupy the home at all times. You know, most of our park rules, we do have rules that say at least one homeowner has to be the registered owner of the mobile home. And I think this client had that rule, but the client did not have this rule that says at least one homeowner needs to occupy the home at all times. But it's like, this seems so stupid. If people are renting a space from us, why would they pay rent and then not occupy the home? Well, it's this situation where they somehow the dad wants to pay the rent and just have a place to have the son living in the mobile home. So if we have a rule like that, it can avoid this situation that just for some reason lately, this year and last year, in my experience, keeps repeating. So okay, the next set of rules is rules about guests. Sometimes, often, it's not our resident that's causing the problem. Many times it's their visitors, it's their guests who are visiting the resident in the park for a great party weekend or something, or whatever the facts are. In RV parks, you have a lot more latitude about how restrictive you want to be. And I was looking at some RV park rules 2 days ago to prepare this outline, and I saw rules like this that said, you know, RV guests permitted to stay up to 3 nights, and to stay longer, the tenant or the resident must register that guest and pay a guest fee. I saw language like number 2 here, which is telling our residents that they're responsible for the conduct of their guests. And that if their guests causes a disturbance and if their guest violates the park rules, that's going to be on you, the resident. And I know some residents are going to be like, wait a minute, I didn't hit him in the face. I didn't get drunk. I wasn't out in the middle of the street. I was in my house with a can of beer laughing about it, but it's my friend Joe. He was a guest and he's the one who was in the middle of the street and he's the one who caused the ruckus. So we need park rules that, basically warn our tenants that, they're going to be responsible. And in both the RV code and the mobile home residency law code for mobile home parks, both sets of laws talk about this. In the RV code, it says that you can actually terminate the resident if the resident or guest, it actually says guest, violates the rules or causes a substantial annoyance. And there's similar types of rules in the MRL. So the law's behind you on this one, so to speak, a little bit. I mean, the law is there trying to support you to have a park rule that says, you, the resident, must make your guests behave. And if you, the resident, don't make your guests behave, I know you, the resident, claim you had nothing to do with it, but nonetheless, you are going to be responsible and we can evict you if you, the resident, don't get your guest under control. In the mobile home park law, they're more restrictive somewhat about what you can do with guests. Basically, under the MRL, guests can stay 20 consecutive days or 30 days in a calendar year and not be charged a guest fee and not be required to register. So in mobile home parks, what you'll see very commonly in park rules is the park rule will say a guest who stays longer than 20 days or 30 days may be charged a guest fee. And we see that all the time, 20 consecutive days, 30 calendar days. The reason why that rule is always like that is because we're trying to abide by the law that says that we can't do anything in terms of fees and registration against a guest for the first 20 days. So after 20 days, then we have our park rules that we require them to register and have a guest fee. Important to say guests have no rights of tenancy. Important to say that any agreement that that homeowner thinks he put together with that guest doesn't in any way affect management's contract with the homeowner or with the resident. And you can tailor your park rules for other types of occupants in a mobile home. Under the MRL, we have various kinds of occupants, as you all know. We have guests, and in addition to guests, we have other people that can occupy our mobile home without a tenancy. Those people include what we call companions, live-in caregivers, and a family member under the care of a senior homeowner. So all these extra occupants, what we're saying is that these extra occupants have the legal right to occupy the home, but they don't have a tenancy. So they have no rights of tenancy, and we don't have to go through the normal termination of tenancy procedures with these people because they're just allowed to be in the mobile home. It's really the homeowner's right to have these people in their home. The tenancy, though, remains with the homeowner or the person who signed the rental agreement with the park. The next one is subleasing. Subleasing seems to be really confusing. Do I allow it? Do I not allow it? What is the law on subleasing? I have clients who allow subleasing, and for clients who allow subleasing, they have some involved rules about how you can go about to sublease your space. I have a lot of other park clients that don't allow subleasing. And so you just have to decide with your business model whether you want to or not. On the MRL side, on the mobile home park side, you can have a rule that says no subleasing, but there is a statute that says that if the homeowner gets sick, has a medical emergency or treatment, and that medical emergency or treatment requires that person to be, gone from the park, then if you get some doctor's note, by law, that person in the mobile home park, that homeowner has the right to sublease while they're away during their medical emergency. Again, the last part, number 3, I think it's just useful. Just keep in mind, it's nice to put some rule in there that, they need to respond to your inquiry when management makes an inquiry as to who these people are living in the home. And we do that somewhat with estoppel certificates, but you might want some type of rule like number 3 down here, where basically the situation you're going to find yourself in is, well, Dan, I know I rented it to Tom, but Tom has a bunch of unknown people living with him. And I really don't know who these people are that are living with Tom. And so if we had a park rule that said that the management can ask them to state in writing who's living with them, they may lie, but what we're trying to do is get a process together where we can make inquiries to the homeowner or the resident Tom and get Tom to admit to us who are these people that are in the home. So then we can determine if they're a companion, a guest, and what are the rules with those other people. The next issue, maybe this issue of heirs doesn't come up too often. I think we have had it come up with a RV residence, but we have had people who have inherited RVs in an RV park. Most of the time, the issue of heirs comes up in mobile home parks. So I think what we have is in a mobile home park, your rental agreement is with the homeowner. And when the homeowner dies, his rental agreement or her rental agreement dies with him or her. But under the MRL, they have special rules that when the homeowner dies, that homeowner's heir or joint tenant or personal representative of their estate who inherits the mobile home has a statutory right to sell the home so long as that heir pays the space rent to the park manager. It seems like such a simple, straightforward rule. Why are we talking about this rule? This concept and this rule comes up every day at our office. We have 3 or 4 files in our office right now where it's a problem, because usually the problem is that the heir, for whatever reason, moves into the mobile home, which they can't do. They can't move into the home and start paying rent to the park manager. The park manager is going to inadvertently start an oral tenancy with the heir if we let the heir occupy the mobile home and pay rent. But it happens. I have 3 files on my desk right now where there are variations on this. One is an heir moved into the mobile home. I have another heir that while the homeowner was alive, the heir was the daughter and moved in as a caregiver. So she really was a caregiver. And then when the homeowner died, she refuses to leave. And so she's technically, I guess, an heir and a caregiver. Neither being an heir who inherited the home, nor being a caregiver gives her any rights of tenancy. She has no right to be in that home. And so that usually requires that we give a 5-day notice to the person who's essentially a squatter. And after 5 days, we file what we call a forcible detainer complaint in court in order to get a judgment for possession. And eventually we have the sheriff lock out this person who inherited the home and didn't understand, no matter how much we explain it to them, that they can't live in the home. I've had one case where I have clients that are the heirs and they're behaving themselves. The heirs are fine. They inherited the mobile home, but their brother is the one who died in the mobile home. Their brother is the homeowner who died, and their brother who died had a girlfriend, and the brother's girlfriend won't move out of the home. And so we might want in that situation rules tailored that say something to the effect, like on number 3 here, no unauthorized persons may occupy the home, because this may be helpful if we're trying to tell the heirs that they need to get their strange, girlfriend person out of the home. Oh, all about pets. Of course, pets do continue to be a source of business for our law firm, in the sense that we do get a lot of questions through the Camp Cal Now hotline, and just my own clients that call me directly. Just pets do constantly cause problems. The situation with the mobile home parks and RV parks is, well, let me start with mobile home parks. With the mobile home park, they basically passed a law saying that the homeowner has the right to keep one pet. And one pet is defined as any domesticated bird, cat, dog, aquatic animal, and then it says, or other agreed upon animal. And I put my little 2 cents there and I say, don't agree to another type of animal. I think it's really hard for you to, start approving other types of animals, like, a person's snake or a person's some other kind of animal. I think the problem is, once you agree to allow one person to have a snake, then other people are going to want snakes, and then other people are going to want other animals, the other types of animals that are more dangerous, and you're going to say no to them, and then they're going to say, well, that's unfair. How come you allowed him to have a snake and you won't let me have a cheetah or a monkey in my home? So I think it'd be a pretty good practice just not to agree to any other animals other than what the code allows them to have. So the situation with pets is this. With mobile home parks, on the one hand, the law says that they're allowed to have one pet. But what the law says is they're allowed to have one pet subject to the park's reasonable rules and regulations. So we, as operators of the mobile home park, and we as operators of the RV park, we are entitled under the law to draft and adopt and enforce reasonable rules. And there are many, as I think many of you know, when it comes to pets. And I just gave you samplings here of all the different rules that people have done, that, they have to be registered, they can't be so many pounds, they can't be certain breeds, they have to be licensed, they can't be in certain areas of the clubhouse, they always have to be on a leash, they can't disturb anyone, and your guests can't bring pets into the park. Basically where we're at is management is trying to get control of this pet problem. We have a lot of pets running around without a leash on. We have a lot of pets that have attacked dogs that have ran across the street and attacked and injured another homeowner or resident. Day before yesterday, on Tuesday, my associate had a trial on Zoom with a judge in Orange County Superior Court. The case was about one homeowner who had a dog. The dog got loose, ran across the street, attacked another homeowner in the park and bit her leg. She was okay, but she needed to go to the emergency room and have stitches. So a very traumatic event for her. And we do handle those kind of cases. And for whatever reason, now the homeowner is refusing to move out, requiring that we take him to trial. You might be submitting a question and saying, what about service animals? What about emotional support animals? I think what's useful is to distinguish the two different things that we're talking about. Pets are pets, and the service animals are not pets. Service animals are service animals. There's animals who are providing a service. And there's a bunch of laws and rules regarding service animals and emotional support animals. The laws are very intricate about what documentation you can ask for a service animal, what kind of service animals they can have. You and your attorney can work through the nuances of all the rules having to do with service animals. But I will leave you with this thought that every time I have reviewed the laws on service animals, although they have a lot of rights to have service animals, there seems to be always an exception at the end of the law for any service animal that's dangerous. And I'm just paraphrasing, but I mean that, service animals that are dangerous, are a threat to other people, service animals who have attacked other people, you end up losing they end up losing the protection of a service animal. So I just leave you with the thought that service animals, yes, they have a bunch of rights to have service animals, but service animals can't be dangerous and injure and attack other people, which probably is kind of, duh. But I mean, that's sort of something that's very important to a distinction on. This last part, document the pet violations, note who witnessed the violation, such as maintenance and landscaping persons. I've had a trial before about 2 years ago on service animals that were causing a bunch of problem. And we actually did a full-blown trial. And I actually had to put the maintenance man at the park up into the witness stand. And I had to have that maintenance man tell the judge that he, the maintenance man, with his own eyes, saw their dog come out of the mobile home running around without a leash on. And day before yesterday, in our trial that hasn't ended yet, on the trial we're doing right now on the dog bite case, the judge is wanting more evidence as to who exactly witnessed the dog bite incident. Meaning the judge that we have in our particular case is not willing to just accept the manager's word for it that there was an incident. And the manager wasn't there at the time, actually witnessing this dog attack. And the manager is saying to the judge that she received all these complaints and the person who owned the dog isn't disputing the incident happened. But the judge is nonetheless requiring that people with personal knowledge who witnessed the attack testify in court. So when you have something major, like a dog attack where it actually physically injured another person in the park and there's blood and stitches and calling the police and calling an ambulance, make sure you document everything as much as possible. Who was there? What other residents were there? Who witnessed it? What are their names? What are their phone numbers? Take photographs, because you never know what type of lawsuit there's going to be against you, maybe by the injured homeowner. Or you may say, you'll be immediately contacting your lawyer to evict the person who had the dog that did the attacking. And you'll want to give all the evidence you can to that attorney so the attorney can do the eviction trial against the person. We're doing pretty well on time. We're about 36 minutes into it. So I'll finish up these last 3 or 4 rules. Rules about upkeep. Definitely, we can't have enough rules. I try to, and these aren't all the rules that I have on the ones that I do, but yeah, everything and anything about cleaning up their lot. And this is, of course, very applicable to RV parks as well as mobile home parks. No hoarding, not erecting some fencing without the management's approval. Clarifying who's going to maintain the driveways, clarifying who's going to maintain the trees. In the RV parks, that no tents are allowed, no fireworks. Each RV will only have 1 space. On these, I did underline number 6, prohibit damaging common areas. This is one of those quirky things where you would say to yourself, I can't believe we need a rule about this, but I've had 2 different files. On one file, I had a resident in a mobile home park. For whatever reason, he was digging a trench on the park's road in front of his mobile home. It's like, well, that's wrong. Well, he shouldn't be able to do that. I forget why the guy was even digging the trench. It wasn't very big, but it was big enough that when I saw it in photographs, I could see it. But he was literally damaging our park road that was in front of his home. And yet the manager was very frustrated when she came to me with the file because she said, Dan, we don't have any park rules that say they can't dig a trench in the road, and we don't even have a rule that says you can't damage the common areas. That was one case. And then I'm handling currently a new case where the guy's space is at the end of the street and his space is really nice, and he's his space is surrounded by a green belt. And for whatever reason, he took it upon himself that he could start digging up the grass around his space. The grass is all the common area, and started planting flowers in the common areas around his space. It seems kind of, well, that seems so harmless and maybe it looked pretty, but he then started using the water from the park, or using too much water. And then there gets into irrigation, drainage, runoff, water runoff. And this second client that I had no, similarly had no park rule that you can't damage the common areas or touch the common areas. Or I'm not saying that we have a rule that says you can't plant flowers in the green belt. What I'm saying is that we unfortunately need rules that they can't damage, tamper with, touch our common areas, and give some examples, but have a very broad rule there, because I've had 2 files where this has come up. And it's one of those things, intuitively, you wouldn't think we would need one of those, but unfortunately, I think we do, so.
Hey, Dan, a question that came up on that I
Sure.
know we have a few questions, but one pertaining to this is, isn't not damaging park property or areas assumed or implied, regardless of whether or not it is written? I think part of this question with the guy with the flowers, and I know this case in particular, could it actually be seen as damaging? He wasn't really damaging it, right? He was enhancing by adding flowers. The problem then became, bigger when the water came into it, and some mess and some runoff and things like that. What is your opinion on that?
Well, the question that you're relaying to me, the question from our person is, well, Dan, can't you go to court and say it's implied that there's an implied rule that's not in the park rules, but it's implied that you can't go around and damage our clubhouse and pool? Yeah, you would think that, but unfortunately, we have a bunch of very pro-tenant judges that are on the bench. I say pro-tenant, but I mean, the judges are just trying to be fair, and the judges take the bench and they're just trying to follow the law. What the law says is, with respect to your people who live in a mobile home park, and with respect to people who have lived in your RV park for more than 9 months, if you want to terminate their tenancy for violating your park rules, you have to serve them with a 7-day notice that informs them in the 7-day notice what rule in your park rules have been violated. And then the law requires that you give them the 7-day period to try to comply with the park rules. And then if they haven't complied with your park rule within 7 days, only then can you serve them with a 60-day notice of termination of tenancy. So when a question is, well, can you argue there's an implied rule? I would say, no, you really can't. It is difficult enough with some of our judges just to make out our legal case to say, Your Honor, we actually had rule number 2 in our park rules that said you can't damage the clubhouse. Then he damaged the clubhouse, and I have witnesses that he damaged the clubhouse. I, the manager, wasn't there, but I got complaints. I interviewed people. I took a photograph of the damaged carpet in the clubhouse. Then I gave him a 7-day notice, and then he calmed down. And if he calmed down, doesn't repeat the rule, you can't really evict him per se under the law. So it's really one of those things that we actually have to go through this whole thing. The other thing about, I know Diana knows the particular case. We won't give out the name of the client or the park, obviously, but Diana was saying, I know the client we're talking about planting the flowers on the side of the riverbed. The park manager didn't want any more damage to their property, and so told him not to remove the flowers. So then we got into an issue of whether or not we allowed this person an opportunity to cure within the 7 days. So I would say, no, we can't go into court and just say that, that we have an implied rule that you can't do this or that. It seems ridiculous, but that's why we even have rules about no fighting, no, physical assaults, things you'd think, well, duh, if he physically does an assault in the middle of the street and hits someone to death, I mean, you can't evict this person. Well, you can say it was a substantial annoyance if you have witnesses, or if you're going to say they violated your park rule based on conduct, then you've got to, have witnesses and evidence and a 7-day notice. This one is real brief. I think we all are familiar with this one. Rules about speeding and parking. I just kind of copied and pasted a few rules that I found in an RV set of park rules about, maximum 1 RV and 1 vehicle per space. Vehicles can't extend into the roadway or park fire lanes. With the RV parks, I see more of this language: no vehicle washing, no oil changes, no vehicle maintenance. Basically, we don't want people, working on their engine in the middle of the RV park. And I see that more, and I see those rules often in RV parks rather than mobile home parks rules. I don't know what Megan, my IT person, was doing here with the cartoon. I guess these are people dancing. These are people partying. And I guess they're going to be partying past 11 o'clock because Megan gave us a clock of 11 o'clock. So I'm trying to figure out, Megan and I haven't discussed this piece of artwork here, but I'm thinking that's what she came up with. So she thought this would be good about conduct. I think that rules about conduct are the usual ones. You behave yourself, don't do this, don't do that. I think you want to address what's your park policy going to be about smoking and marijuana? That's a little bit more of a complicated question than you would think, because marijuana is legal under California law, but I guess it's not so legal under federal law. You might have a park that has a mortgage on it, and you may be getting letters from your mortgage company that tells you have to be in compliance with all federal laws because this is a federal mortgage. And so then you're scratching your head and saying, well, am I allowed to allow them to have marijuana in my park or not? So that's something to think through. The one main thing, and I tried to underline things that I definitely wanted to touch upon, is we've had, unfortunately, a lot of incidences where residents come into the park office and they're very belligerent to the park manager. Our park managers, I know, take all the bad stuff. They're our first line of defense. But I've had several terrible stories about, people coming in and yelling and screaming at the park manager. And what lawyers say is, well, if this is something incredibly serious, then of course dial 911 and call the police to come out. And that's fine. Maybe the police come out and the disgruntled resident, talks to the police and goes back to his space. But then again, it's like, okay, that was unacceptable. That was unacceptable. And I don't care what kind of business we're running, we're not allowing our park managers to be subjected to that. And yet when we turn around to terminate that person, we look at the law and we say, well, we have to prove a substantial annoyance to other residents. And it doesn't say anything in the law about the park manager. And then we look at our park rules, and our park rules say you have to behave yourself and you can't do anything belligerent to other residents. And again, our park rules don't say anything about the park manager. So I think we need to start protecting our park managers. I think we need to have rules in here that you can't do any type of threat or annoyance or anything to the park manager. And if they do threaten and are obnoxious to the park manager, and if we terminate them for violating our park rules about this, I'm thinking that judges are just not going to put up with that they're going to side with the park when there's been abuse of the park manager. And the last one, number 10, is what I know a lot of park owners are struggling with is they come to me and they say, Dan, our resident is violating some provision in their lease, but it's not in our park rules. But this is really serious. They need to comply with this part of their lease. And my manager and my park owner is very upset. They want this guy to either comply with their lease or we need to terminate them. And the problem is, well, under the RV code, when they've been there longer than 9 months, and under the mobile home residency law, simply saying, Your Honor, they violated a term in our rental agreement is not enough to evict someone. It's got to be in your rules. So what we've been trying to draft lately as a rule that is like rule number 10 is saying that, we're going to make it a rule that you're not allowed to violate any term in your contract. And that's our park rule. You can't violate any term in your contract. So that maybe next time we get a case where they say, hey, this guy violated this term in the contract, we can maybe use rule number 10 here to say, well, Your Honor, it's against our park rules to violate the leases, and they violated the leases, and so that violated our park rules. And Your Honor, we gave them a 7-day notice because this lease violation technically also violates our park rules pursuant to rule number 10. And we gave them I would probably give them 2 or 3 7-day notices, depending on what the breach of the term is. It's usually nothing too major. It's not a health and safety risk usually. And then that way we have something to hang our hat on and to solve for this problem that keeps coming up with people who violate our leases and we can't terminate them. Real quick, we're already at 150, so let me just finish up we just have 2 slides left, this one and the next one. Real briefly on changing rules, under the mobile home residency law, you have to give a 10-day notice of a meet and consult meeting with your homeowners. Your notice has to say what the changes that you're proposing to your rules, and of course, give them notice of the time and place for the meeting. At that meeting, the homeowners do not have the right to require a change to your proposed rule. And we usually recommend that at the meeting, you don't change the rules the way that residents wanted you to make last minute changes, because then you might need to reserve a 10-day notice to have a whole new meeting and start the meet and consult process all over again. Does
that apply to RV parks too, Dan?
They don't have this rule with RV parks. So okay. I'm thinking that, with RV parks, the RV occupancy law doesn't say how you amend the park rules. So I have most of my clients who own RV parks like to just distribute the new set of park rules and tell everyone they have 60-day notice. That seems to be kind of a rule of thumb. It's not pursuant to any kind of statute, but lately all the clients want to give people 60 days notice that these are the new park rules. With the MRL, after the meeting, people can consent to being subject to the rules, or you serve them with a 6 months notice, and after 6 months, the rules become effective as to them. Why would someone consent to being subject to the rule early? Occasionally, you're going to allow maybe someone to do something that you didn't let them do. Maybe you decided you're going to have a new park rule that people can now have parties in the clubhouse if they register all the names of the guests and pay a deposit. And someone might say, that's great, I want to have a party tomorrow. Hey, yes, I will consent to the new rule. You don't have to wait 6 months before that rule becomes, before I become subject to that rule. There's the last thing I want to talk to you about is always, when we talk about rules today, your rules need to be reasonable in order to be enforceable, because the law keeps talking about your right to adopt reasonable rules. And if we get to court and the judge is very pro-tenant, the judge may say, well, counselor, I'm not going to enforce this park rule because I don't like your rule. I don't think it's reasonable. And under the law, your rules need to be reasonable in order to be enforceable. The only one, and I've mentioned this at other Camp Cal Now webinars that we've done, and I know I'm sounding like a repeat record, is the only one so far that I've found a rule to be, in my personal opinion, to be unreasonable is maybe a rule that says you can't walk your dog within the mobile home park. It seems like if you have a statutory right to have a dog in the mobile home park, to say you can't walk the dog in the park may seem a little unreasonable, but that's just my opinion. I've seen it in more than one set of rules say that you have to go outside the mobile home park to walk your dog, but that's just my 2 cents on that one. And then this is the last slide. Just keep in mind with the RV parks that if you're trying to remove an occupant from your home, from your park that's been there less than 30 days, you need to give them a 72-hour notice. No 7-day notice is required. And I'm just putting here in this first bullet point that it's not really clear how much detail you have to get in your 72-hour notice about the rule violation, but you probably should put something in there about why you're giving them the 72-hour notice, putting in there that they violated a rule. Most of the time, people are giving 72-hour notices because they didn't pay the rent. For your tenants, remember your tenants are people that have been in your park over 30 days, but less than 9 months. They can be terminated without cause on a 30-day notice, or you can give them a 3-day notice for non-payment of rent. When you serve them with a 30-day notice without cause, don't mention the rule violations, don't mention even the cause. You're giving them a 30-day notice that their tenancy is terminated. The law does not require you to specify why, what your grounds are, what your cause are. And I would recommend that you don't put it in the 30-day notice, because they will simply look at that and chew on it and dispute it and say whatever you said in your 30-day notice is wrong. It wasn't me, it was the other guy who, hit him in the face or whatever. And then, of course, with your mobile home park and your RV residents who've been in the park longer than 9 months, like I said earlier, you need to give a 7-day notice that they violated the rule. You need to give an opportunity to cure, and you need to be able to show the judge that after 7 days, by day 7, they still didn't comply with the rule. It's almost like an opportunity to cure rule. They get the opportunity to cure. And if they cure the rule violation within 7 days, you can evict them. And we can talk offline about, well, what if they keep curing and repeating the rule violation and then curing and repeating the rule violation? That is a problem that we work on with our residents. Diana, you said, one last question, you said, how often should we have our park rules reviewed? I would say probably at least once a year. The reason why I say that is because the MRL is revised every year. Maybe sometimes it's revised a lot. Sometimes the MRL is revised just in a few different places. And the new changes under the law go into effect every year, January 1. And so I think it's a pretty good practice to say, okay, what are the new laws and how does that impact my park rules, and should my park rules be changed?
Yes, excellent.
Do you have access to any questions there, Diana, that you can read to me?
We do actually have some, and I just wanted to put in that I think one of the very first rules you mentioned was listing these, these notices, listing that at 30 days, it's a 72-hour, that at less than 9 months, it's without cause. Because I cannot tell you the number of times we get calls from parks that say, well, somebody walked in here and they told them I didn't have the right to do this, that there's not a 72-hour notice, that it's not without, and they want to argue it. Well, when it's in your rules, you can say, well, it was right here, and this was given to you when you checked in. So here it is, then it kind of stops that right there without then causing you to rethink what you're doing. And so it's important to remember. I think that was one of the keys that I took away with it. Yeah, that needs to be in your rules for sure. Okay, so we have Kristen said, what would be a reasonable amount of time for someone to present a registration or title on a new purchase occupancy? Many people don't have this from HCD upon approval and escrow closing.
I think, Kristen, we would probably look at the average time it takes people to get it from HCD and probably add on another 2 weeks, I think. Because if they're trying to get it from someone else and the government is slow, I think we should add on a reasonable time and probably add on another 2 weeks.
Rhiannon, these slides will be available, and we can certainly get them out to everybody if you're interested. Anonymous attendee said, regarding rule number 4, can the park require a resident to supply a driver's license or some sort of identification for the people living with them?
The answer is yes. I would say yes. I would say that what you're talking about is a park that's decided to allow subleasing. Rule number 4 was subleasing. So where the park has decided to permit subleasing, you're going to have a set of rules that govern subleasing. And you're going to say, well, we, the park, are going to require that you give us a copy of the driver's license of the subtenant. And I think that's fine. What I caution you about is I then see subleasing rules where the park says the subtenant needs to qualify for tenancy, or the subtenant needs to sign a rental agreement with the park. And that's where I say, no, 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 no. You know, your tenancy, the park's tenancy is with the tenant. The tenant then turns around and enters into a separate subcontract agreement with the sublessee. You obviously want to have control over the comings and goings of your park. You obviously want to have control about knowing who that subtenant is. And so rules that say we need identification, driver's license, information on the subtenant, that's all fine. But we should not be having rules saying that, oh, our subtenants need to apply for tenancy. Some people say, well, no, we should do that because if we require the subtenant to apply for tenancy, we see that they're good people, they have good credit scores, they'll have the money to pay the rent on the subtenancy. I just don't think it's a good process. I think it really blurs the lines then about who is our resident and who we have a tenancy with. So try to keep your contract with your resident separate, and you don't have a contract with a subtenant, although you can have park rules where you can control who these subtenants are.
Okay, here's a good one. What problems arise when a homeowner says that their hoarding is a result of a mental illness and claims an accommodation?
That's a good one. Yeah, that's
good. That was a good one because I see a lot of hoarding.
Yeah, and I'll do a shout out to my friend Larry Weaver. Larry Weaver's been a mobile home park lawyer for many years, and his offices are over here in Cerritos, California. And I've read Larry's papers on hoarding. He's done a whole treatise on hoarding and the Americans with Disabilities Act, and saying that you can make an argument that the hoarding is a mental or whatever, a physical, mental, or biological disease or whatever, and that that they get the benefit of the Americans with Disabilities Act. And what those acts do is they say that you have to accommodate someone. And what that means is it's real tricky, because on the one hand, you have one set of rules and you have to equally enforce these rules to everyone who lives in your park. But then comes the Americans with Disabilities Act that says that if they qualify, you have to accommodate them, meaning you have to make an exception to your rule. Whereas you equally enforce your rules, you have to, by law, agree not to enforce a rule against this one person because of their disability. I would say I wouldn't just let this person, though, hoard completely all down the carport. I think my personal opinion is that if I had that case, I think what I would do is I would say, no, we're going to push it a little bit. We're going to do 7-day notices. We're going to talk to the hoarder. We're going to try to explain to them that we understand that they're a hoarder, and it's not that I'm encouraging hoarding, but maybe, can we work it out and have all the hoarding happen inside the mobile home or inside the RV? But I would think I would still do 7-day notices. And maybe this is something where you really are going to do 3 consecutive 7-day notices. The law only requires 1 7-day notice before you terminate them for violating your park rules. But this may be, I've had one guy in a park in the city of Westminster, California, And that was basically his thing, was he was a hoarder. He was an elderly man. He was very kind, very nice man, not belligerent, not yelling, screaming. He paid his rent on time, but he really did have a hoarding problem. And
Well,
we were very patient with him, and we worked for, I think, like 6 months trying to gradually get his family members to help out. We kind of reached out to his son. He had adult children, and we kind of reached out to the adult children to see if the adult children could understand the park's perspective, that we just really can't have that eyesore. And hoarding comes with a lot of issues. Hoarding comes with issues of it attracts rats from the surrounding area. Animals get into all these boxes, and there's a health and safety aspect to it for the residents who live next door. So hoarding seems like such a nice little thing to talk about, but it can get really complicated.
well, and it seems to me it's one of those things that if you have fairly concrete rules in place for what they're allowed to have outside of their residence, whether that be a mobile home or an RV, it shouldn't ever get to the hoarding stage. So the minute that that one item that is outside of your rules is placed outside, I have parks that have allow you to have one plant outside your RV. The minute that plant number 2 arrives, they get a 7-day notice. And so I think it's important to really stay on these things so that they don't get to this stage that now you're not sure what to do with it.
Yeah, absolutely. And absolutely, because like you just said, the plant thing, what we see it mostly, Diana, was like, you can have one barbecue,
Yeah.
and so it's always this, it's not a perfectly clean carport, or it's never a perfectly, clean RV space. The rules always say, well, you can have one barbecue or something. And then it's kind of like, okay, they have the barbecue, but now they added a refrigerator next to the barbecue. And then it kind of goes from there.
Or a smoker. Yeah, exactly. Or the bins underneath the thing is what gets me.
Yeah.
Pretty soon there was 1 and now there's 40. Okay. If you were to cite someone for violating rule number 7 for damaging, for example, the clubhouse carpet, this sounds like it might actually be an issue, and you serve them a 7-day notice, would part of the complying with the notice be to cure the damage to the carpet? So like our guy who planted the flowers, who then went and ripped them all out and threw them around the street, would the 7-day notice mean that that person has to go in and fix the carpet, or do they just need to stop damaging the carpet?
A great question. Typically, we've had this kind of with driveways. Typically, you, the park owner, are not going to want to allow anyone to touch your carpet in the clubhouse. You're going to want to have your contractors repair it. You don't want to have other people working on your park, hiring other contractors. But what the question raises is, well, I would think that maybe we could craft a rule that they have to pay for the cost of the repair. And if they don't pay the cost of the repair within, so many days, we give them a 7-day notice that they have to pay the cost of repair. I think that's a reasonable rule, that if you damage my carpet area, then, you have to pay for the repair. I may not evict them for a small piece of carpet and where the repair is $50 and they don't pay the $50. I mean, there are a lot of pro-tenant judges out there. So you do have to step back and believe in your case, but you also have to objectively evaluate the strengths and weaknesses of your lawsuit, of your eviction case, and say, is this really worth it? But the problem is, and let's just talk briefly about it, is it's the sort of, I call it the when did they stop beating your wife syndrome thing, is that, what if your resident walks up to someone else and slaps them in the face, and you serve them with a 7-day notice, and it was a horrendous slap, and they have a print on their face and stitches on their nose? What if you serve them with a 7-day notice and they don't ever repeat the slap? Have they cured the violation within 7 days because they stopped slapping someone? Now, I mean, that's just a hypothetical. Obviously, we might be able to get them out on substantial annoyance to other homeowners. But I mean, there are cases where we have a problem where they do something and then they've sort of, by stop doing the bad act, they've essentially cured the rule violation by day 7.
And does that mean they just get to cure and repeat and cure and repeat and cure? And you know, at a certain point, I think we try to combine the eviction with a substantial annoyance eviction, or we just go into court and we say, this is ridiculous. I mean, the MRL does have provisions that once I think you have 3 7-day notices for the same rule violation, you don't have to give a 7-day notice after that. You can go straight to a 60-day notice. So we'd be looking for things like that.
Okay, so can we ask for the estoppel to be filled out and signed if we do not have it on file? And can we enforce it legally? And I will say we're about 10 minutes over, so we have just a couple more questions if you guys want to hang on and listen to the last few. Certainly if you can't, we understand, we'll have this available, but we have about 3 more questions. So this one was, can we ask for the estoppel to be filled out and signed? If we do not have it on file, can we enforce it legally?
You can if it's in your park rules. And that's why we're recommending in the other slide up above on the slide presentation that we're saying to you, put it in your rules. Put it in your rule that you, the tenant, rule number 16, you, the tenant, must fill out and return an estoppel certificate to us upon, 7 days of us giving you the certificate, or 10 days or 14 days. Maybe make it 14 days because 2 weeks seems more reasonable than 7-day turnaround. But the answer to your question is we believe it's enforceable, something you should do, something you should have in your rules, but it's legal and enforceable if you have it in your rules. What are the other last 2 questions, Diana?
Yep. What is the best approach to requesting proof of current registration annually?
Put it in your rules that that you're going to be requesting and that they have to give it to you annually. And like I said earlier in the presentation, don't just put in your park rule that residents have to give me the registration each year. Don't say just that. Give it a deadline. Give it that each year you have to give us a copy of your registration, and it has to be, if you want to say by the 7th or the 10th of each year, or some people come in mid-year and so it's every 1 year, however you want to do it. If you want to keep track of it yourself, then say, annually you have to give us a copy of your registration upon within 10 days after receiving a written request from park management. It kind of puts it on you, but that's okay. I mean, if you calendar things and keep track of your tenant files, then you'll send out the notice to them asking them, hey, give me a copy of your annual, well, it's that time of year again, give me a copy of your registration within the next 14 days or 10 days or 7 days.
And last question, I believe we have. Oh, wait, no, there's another one. How do I handle fencing violations? That might need a little more one-on-one with some more explanation, but.
Well, the fencing problem is we've had some park owners have that problem in the sense that I think, Diana, it's your point that you have to really, good park management means walking your park every day and discovering when that very first fence starts to be built up and they're making a little fence, and you serve them immediately with a 7-day notice saying that that fence is illegal. And this one works out pretty good. This 7-day notice says within 7 days, remove the fence. Now that's a very simple hypothetical. If they're doing a little tiny bamboo fence on their space and they put it up, I think it's reasonable to have them take it down. Whereas before I said, I don't want them touching the repair of my carpet in my clubhouse. I mean, if I'm looking at this hypothetical, I'm saying, okay, just require them to remove the bamboo. Partly because I, the park manager, don't want any liability for touching their bamboo, hurting their bamboo, or hurting their wood, and then they're gonna yell and scream at me that I hurt their bamboo fence. So let's have them just remove it. The problem though we've had with some of our clients with fencing is that for whatever reason, park management over the months or years has not really enforced the fencing rule, and a bunch of different fences keep popping up all over the park. And we've had the situation where the resident says, oh, I didn't install this fence. you know, either the prior resident installed this fence or the park itself installed this fence. And if you have a little bit of changeover in your park management, the client is sort of scratching their heads saying, we don't know, Dan, who really installed this fence. So then it's sort of like, it's not my dog, it's not my fence. And do we have them remove it? Do we go on the space and remove it for them? So fencing can be a real problem. It just snowballs into so many other issues, which in the end is going to cause you, you know, it's like preventive medicine. When it snowballs, you're going to have to spend more time explaining this to the attorney. The attorney is going to have to spend more time studying what the issues are in the history of the park with fencing. So the takeaway today is try to keep a very tight ship. I know it's hard to do. I know we're very busy. Try to walk your park every day. Try to nip things in the bud. Try to give a 7-day notice out today or tomorrow the first time you see someone put up a Mickey Mouse bamboo fence on their space.
Last question. How can I enforce a smoking nuisance? Neighbor is smoking constantly outside and the residual smoke is upsetting the neighbors.
Yeah, we really should have park rules that probably require them to smoke nicotine, cigarettes, and marijuana, I suppose, if you're going to allow marijuana in the park, given California making it legal. We should have rules that say you can only smoke inside your mobile home. Gets a little tricky, I know. You have to have rules that say your smoke can't disturb others, because people are saying, well, wait a minute, I bought this mobile home. This is my mobile home. And my mobile home opens up the front with a decking, and it's my deck. And lots of people, I've known smokers, I've never smoked, but I've had friends who are smokers. Even my friends who are smokers, they won't smoke in their own house. They always smoke on their patio outside, put the cigarette out, and they don't even like the smell of smoke in their own house. But when they have that desire to smoke, they always smoke outside. So we're gonna have people that are smoking on their own deck saying, why can't I smoke, you know, on my own deck? And the idea is yeah, but your smoke travels to the next door neighbor. They can't stand the smell of the smoke. And a lot of people can't stand the smell of marijuana. They just have maybe it's a generations thing that really freaks them out, whereas almost nicotine wouldn't be the same complaint. But in any event, I think we need park rules that say that, you know, smoking, if you want to push it and really push it, think about with your attorney saying they can only smoke inside their mobile home. But if you're thinking, no, that's going to be unreasonable and judge is never going to enforce that, then think about, you know, you can only smoke on your space, nowhere else in the common areas, nowhere on the streets, nowhere in the pool or in the clubhouse. And even though you can smoke on your space, you may not cause any annoyance to any other homeowner. You know, no smoking is allowed that annoys other people. Annoying is sort of just a very low threshold burden, right? So, I mean, if the next door neighbor complains, well, they're complaining, they've been annoyed, and maybe we say, hey, you can't do that, you're annoying them. Again, I'm probably not seeing myself evict this person for annoying the next door neighbor with their smoke, because I worry that the judge is not going to terminate their tenancy based on that. So there's going to be a little back and forth and trying to explain to the homeowner, hey, look, you know, you're disturbing the next door neighbor. They can't stand the smoke. Can you work with us and maybe, you know, smoke less or smoke inside the home?
All right, and that is it for today.
Well, thank you everyone for attending. I really appreciate it. I know Diana does. And her organization, Camp Cal Now, is a wonderful organization that our law firm is a member of. And I know they also have the legal hotline. So you can continue to use their Camp Cal Now legal hotline for a referral to an attorney, not just my office, but Camp Cal Now has other attorneys also on their panels. So please use that service because it's a great service. And thank you very much.